Hello, this is Attorney Doug Jones. Welcome to Elder Law in 5 Minutes, and hopefully you got our newsletter today. If you didn't, by the way, go to elp.legal and sign up. It's free. And today our newsletter is entitled Don't Leave It to Chance. We're talking about healthcare documents, specifically healthcare power of attorney and private living will. It's critical to have these documents set up in advance, because if you don't and something bad happens, namely a healthcare emergency, then it may be too late to do it. So let me tell you a quick story. Unfortunately, this is a real story. It involves me and my mom. My mom had several years ago, she had a devastating stroke at home, unexpected, and from that point forward, she was unable to make healthcare decisions for herself. I had to make them for her. I was the one that she had appointed to make healthcare decisions. She had a healthcare power of attorney, a private living will, HIPAA authorizations, and other healthcare documents in place. And I often wonder what would have happened had she not had those things in place. Who would have made decisions? What type of care did she want? Where did she want to receive the care? Would she have wanted life-sustaining procedures? Would she have wanted to be hooked up to a feeding tube? All of these decisions would not have been made in advance. So it's crucial to have these decisions made, have the person appointed you want to make healthcare decisions for you, and even have a backup person named in case number one fails to serve. They may die before you do, they may be incapacitated, they may be out of the country, or they may just decide they don't want to serve. So it's important to have a number two in place. I just wanted to review, and now I'm going to be quoting Arkansas law here. If you live in a different state, the law may be just a little bit different, may be totally different. So you need to consult an attorney in your area. But the Arkansas Healthcare Decisions Act, there's just a couple of provisions here I want to point out. It says the agent, that would be you, if your mom or dad appointed you, an agent shall make a healthcare decision in accordance with the principles, individual instructions, and other wishes to the extent known to the agent. And in the absence of individual instructions, I'm paraphrasing here a bit, the agent shall make the decision in accordance with the agent's determination of the principal's best interest. And in determining best interest, the agent shall consider the principal's personal values to the extent known to the agent. It's important to have a conversation with the people you want to serve on your behalf. I can't tell you the number of times over the years I've had one of the adult kids say something like, I know I did the right thing, but I never had this conversation with mom. She never told me. And you can just tell they had like a weight on their shoulders, a heavy weight. And this is particularly burdensome to them as if they had to make an end-of-life decision, what we refer to sometimes as a pull-the-plug decision. If they were the ones responsible for making that decision, mom never told me that it was okay, that it was okay that I make this decision. And the logical part of them lets them know that, hey, I did the right thing, but mom never told them that. So, it's important to have these things in writing, but it's also important to have the conversation with your kids or whoever you want serving on your behalf. So the healthcare power of attorney, who would make healthcare decisions, but, you may also have a living will. Now, in some cases, a living will is incorporated within a healthcare power of attorney. Sometimes it's a separate document. And again, I'm just going to paraphrase a portion of the Arkansas living will law. If I should have an incurable or irreversible condition that will cause my death within a relatively short time, and I'm no longer able to make decisions regarding my medical treatment, or, and this is a separate paragraph, or if I should become permanently unconscious, then you got a couple of choices here. I direct my attending physician, so you may never have seen this person before. It may just be like an ER physician, pursuant to the Arkansas Rights of Terminally Ill or Permanently Unconscious Act, 1, withhold or withdraw treatment that only prolongs the process of dying and is not necessary to my comfort or to alleviate pain, or another option here, to follow the instructions of blank, who I appoint as my healthcare proxy to decide whether life-sustaining treatment should be withheld or withdrawn. So, if you choose that second option, follow the directions of blank, it's very important to have a discussion with this person to let them know what you would want and how you would want it to play out, under what conditions you would want life-sustaining treatment withdrawn or withheld. So it's not easy if you're in that position. Cindy and I have both had to make this decision for our moms as they were dying, and so I've got the t-shirt that says it wasn't an easy decision, and you may have done that for your parents as well. But if you don't have these documents in place, they're crucial documents to get in place, and these are crucial conversations to have with your kids. If we can be of assistance to you, please give us a call, 501-843-9014, or visit our website at arcelderlaw.com. Thank you for watching today. Have a great day.